Okay, it's 1 o'clock, so why don't we get started? Good afternoon to everyone, and welcome to Gowling WLG's webinar, Canadian Public Companies and COVID-19. Today, our panel will discuss some of the key issues facing Canadian public companies as a result of the pandemic, including disclosure considerations, available regulatory relief from certain public company requirements, and the holding of virtual AGMs. We've already hosted several webinars relating to the impact of COVID on M&A transactions as well as financing activities. We've listed our past and planned webinars on the next couple of slides. If you missed any of the webinars in our series, on-demand versions of each webinar is posted on the Gowling WLG website. So before we get started with today's presentation, there's a couple of housekeeping points. To view the presentation and all speakers, please click on the speaker view in the upper right-hand corner of your screen. For questions throughout the session, please use the Q&A button on the bottom of your screen. We'll try our best to answer some of your questions towards the end of the session, and you should feel free to reach out to any of the panelists if you have any follow-up afterwards. This presentation is being recorded and it will be posted on our website in a few days if you'd like to re-review any of the sections. And for those of you who are lawyers, this program counts for 1 hour of continuing professional development credits in applicable jurisdictions, and details of those credits are set out on the invitation to the webinar. Because this presentation is being put on by lawyers, we would be remiss if we didn't include a legal disclaimer. So here it goes. Today's session will be a high-level overview for general information purposes and does not constitute legal advice. Information has been summarized and paraphrased for presentation purposes only, and examples have been provided for illustration purposes. Responsibility for making sufficient and appropriate disclosure and complying with applicable securities laws remains with the company. Each company's situation is different. For specific legal advice to the topics discussed today, please contact your legal counsel. Information in this presentation reflects securities laws and other relevant standards that are in effect as the date of this presentation. And so now on to our panelists. Our presenters today all have extensive experience in acting for publicly listed companies and have firsthand experience in providing guidance to such companies during this unprecedented time. Therefore, they will be able to provide both an overview of the legal considerations that will be relevant to public companies, as well as offer practical insights based on their firsthand experiences. So starting in our Eastern offices, we have Kathleen Ritchie, a partner in our Toronto office, Warren Case, an associate in our Toronto office, Michael Garelek, a partner in our Montreal office. And moving to our Western offices, we have Martin Mix, a partner in our Calgary office, and myself, I'm Cindy Laval. I'm also a public company lawyer and a partner in our Vancouver office, and I'll be moderating today's session. Okay, so let's turn to our agenda for the next hour. Warren and Martin will be discussing how public company disclosure has evolved since March, as well as providing some key guidance offered by the Canadian securities regulators on MD&A, forward-looking statements, and material change reporting. Martin and Michael will give an overview of some of the blanket regulatory relief and Canadian securities regulators have granted to listed issuers and the impact of this relief. And finally, Kathleen will lead a discussion with Martin, Warren, Michael, and myself about how to conduct a virtual AGM and the potential challenges of this format. And of course, during each topic, we will address some practical implications and share with you some real life stories. Again, we want this to be an interactive discussion, so please share your questions with us and we will try and address them at the end. So now let's turn to our first topic, disclosure obligations for public Canadian companies. It's critical for companies grappling with the impact of COVID-19 on their businesses to consider their disclosure obligations and make reasoned and informed judgments about communications to the market. At this stage, the uncertainty about the magnitude and duration of the pandemic may make it impractical for most issuers to quantify its impact on their businesses, even if issuers have suffered a direct material impact already. However, it's becoming increasingly likely that the impact ultimately will be material for most issuers. As a result of this uncertainty, Canadian public issuers will need to decide almost in real time what to disclose regarding the pandemic's implication for their businesses and when to disclose it in order to satisfy their disclosure obligations. Now that we have a couple of months behind us, certain trends are emerging and the regulators have provided some guidance. So I'll turn this session over to Warren and Martin now to discuss some of the disclosure considerations that will be most relevant to public companies.
Thanks so much, Cindy. Thank you for the introduction. So today, Martin and I will cover MD&A, material changes and material change reporting, and forward-looking information. So turning first to MD&A. The overall purpose of this document, which I'm sure you're aware, is to provide a narrative explanation from the perspective of management of what financial statements show and don't show. So these are things that are not obvious or self-evident from the numbers. The securities regulators, expect issuers to provide information and discussion of trends and risks that are affecting their financial results and that are reasonably likely to affect them in the future. There are a few sections that COVID is going to pop up in as an important consideration when drafting your MD&A. The first of which is the discussion of operations section. So this is the part of the MD&A where you discuss factors affecting the relationship between cost and revenue that the business has realized. Management provides its analysis of operations, revenue, sales, cost of sales. They communicate expectations to the market about how they're going to develop the milestones they're hoping to achieve and the cost of achieving those milestones. As well, they'll discuss risks and uncertainties that may materially affect their future performance. So in light of COVID, there are a few parts of this discussion that might be affected. Issuers may be experiencing changes in revenue from ordinary operations. They may be experiencing different costs of sales than they used to, and differences in overall gross profit. There might be revisions to the expectations as opposed, with respect to objectives and milestones that they hope to achieve, and there might be a need to communicate those revisions to the public. There also might be instances where issuers have chosen to reallocate the proceeds of financings from what they previously disclosed they would be using those proceeds for, and that is required to be disclosed in this section as well. So the most recent guidance from the Canadian Securities Administrators is that they want to see, where possible, quantification and very specific discussion on these points. So if, for example, COVID has affected demand for products and services that the company provides, you might consider saying we've experienced a 15% decrease in sales versus the comparable quarter, as opposed to merely saying a decrease. If there have been supply chain or distribution channel issues, you would want to discuss the effect of border restrictions, the availability of raw materials, international logistics, whatever the causes for those issues might be. If you are, have some of your locations that have been closed due to emergency orders, rather than merely saying that, you might give, the flavor of, we have closed 100 out of 500 of our stores and they will remain closed. If there have been breaches of material contracts, those are key issues that should be discussed here as well. Workforce and HR changes is something we've seen quite a bit of, with disclosures such as numbers of employees furloughed and dollars dollars and cents and percentages of budget that companies have been able to save as a result of those workforce reductions. One key discussion that the market will be looking for in this section is, if your business has been significantly affected, what measures have you implemented to adapt to the new environment in which you are operating, and what expected changes to your business plan will be affected on a going forward basis? Have you deferred any capital expenditures that you had, disclosed you plan to undertake? And what is the dollar value of those capital expenditure deferrals? Another important subject in this part of the discussion is the impact of government support and insurance payouts. You could say that, the company has received or is eligible for X dollars in loans, lease subsidies, wage subsidies, these kinds of considerations, always being conscious where possible to give quantification. And on the topic of, financial capacity, I'm going to turn this over to Martin to discuss MD&A discussions of liquidity and capital resources.
Thanks, Warren. Among other things, another critical item that an issuer is required to specifically describe in its MD&A is its liquidity position and availability of capital resources. The purpose of this disclosure is to provide investors with insight into the adequacy of access to cash on hand and financing available to meet working capital requirements and planned capital investment, including disclosure relating to trends and expected fluctuations. However, frankly, this disclosure from time to time can tend to be boilerplate for issuers with very little variation over reporting periods. However, the CSA has provided guidance that stresses that this is probably not appropriate in the current circumstance, and that issues should specifically consider and describe the impact of COVID-19 on their liquidity position and resources, rather than just relying on boilerplate or updating past discussions which may not have considered the impact of the pandemic. In CRA's view, specific points an issuer should discuss include how COVID has impacted an issuer's liquidity position, its AR collection, and whether there are any issues or if new credit terms have been offered, its ability to satisfy contractual liabilities, including debt liabilities and obligations, lease payments, earn-ins and options, etc. Disclosure should also speak about any defaults and arrears that have occurred or expected and how the company plans to deal with them, and any change to the company's dividend or distribution policies. I think as a result, issuers will have to consider the liquidity position more carefully and provide more detailed disclosure than they have in the past, bearing in mind these critical points that the CRA have raised. Back to you, Warren, to discuss risk factors.
Okay, so we have reviewed a number of public disclosure filings on SEDAR, and these suggest that a majority of issuers have turned their attention to disclosing risk factors related to COVID-19. But many of them are still using broad, all-inclusive risk factors relating to disease outbreaks and pandemics, inserting, where applicable, references to COVID-19. For example, our business results of operation and financial condition could be adversely affected by the outbreak of contagious disease, such as COVID-19. Or perhaps, listing COVID-19 as one of the things that is covered by the catastrophic events risk factor that also talks about things like natural disasters, wars, political disruption, force majeure events in general. However, those were good disclosure at the beginning of March and, perhaps in a past disclosure cycle when the effects of COVID-19 on businesses were still very much unclear and uncertain, and there were a lot of question marks. Now, there are still a lot of question marks, but management has had time to digest some of the implications and things may have become a little bit clearer. So at this time, it would be prudent to add more robust and specific risk factors instead of, or as a supplement to, the broad hypothetical ones. The CSA has, said they again want issuers to avoid boilerplate risk factors and to be as specific as possible. So there are a number of possible ways that businesses could be facing risk. I'm not going to list all of them, but I'm happy to discuss them, as would your counsel be. But for example, if we were to hypothetically say that there was a meat processing plant, to pull an example from the news, that was a public company and making disclosure, they might consider talking about their reliance on a skilled labor force that cannot be quickly replaced in cases of mass absences, resulting in potential decreased production or plant closures. They might talk about the inability to fully mitigate health and safety risks due to the necessity of physical proximity of their workers and consequent risks of legal liability as a result. They might also discuss the rapid shift in demand from commercial use channels to personal use channels for the distribution of their products, and their ability to adapt processing and distribution to where the market is providing demand right now. And another factor that we should be conscious of when looking at interim MD&A specifically, and specifically for venture issuers that are using the quarterly highlights format, is the necessity of potentially having to update risk factors in those documents where they otherwise ordinarily would not. Because interim MD&A is required to update the company's most recent annual MD&A. And quarterly format highlights is a format that is available to venture issuers. It's even more abbreviated. It is just a quick summary of highlights of what has occurred in the quarter. The securities regulators have indicated that discussion and analysis can omit things that would simply repeat what is contained in the most recent annual MD&A if the same disclosure still applies. And issuers often omit risk factors if they haven't changed. But under the current circumstances, there's a very good chance that risk factors have changed. So we recommend examining that and included updated risk factors where appropriate. Martin, I'm going to turn this over to you to discuss material change reporting.
Thanks, Warren. I think another matter issuers have been grappling with is how and when they might have to disclose a material change in their business as a result of COVID-19. As you know, issuers have an obligation to immediately issue and file a press release, and then to file a material change report within 10 days if there is a material change in an issuer's business operations or capital that would reasonably be expected to have a significant effect on the market price or value of the issuer's securities. However, it's important for everybody to note that material change reporting obligations are tied to specific changes in your company's business operations or capital. So I think you have to look at the impact COVID-19 or any related regulatory or legal policies or changes are having on your company. This means that the decision to file a material change report is contextual based on your circumstances and the likely market impact on the value or price of your securities. For example, the CSA has suggested in their guidance that if you're affected equally as others in the same industry, then a material change report might not be required. So ultimately, whether or not to issue a press release and file a material change report is a judgment call for a company and its management. The environment is evolving rapidly, and what is not a material change report yesterday may quickly become one today. Some of the situations where issuers have issued a material change report in response to the pandemic include suspension or resumption of material industrial or resource extraction operations, material sales decreases, cancellations of dividends or other distributions, layoffs, retail closures, and supply chain disruptions. Given the rapidly changing environment and the significant impact COVID-19 is having across the economy, it's tough for issuers to stay on top of things. However, some of the things we think issuers might like to do in order to try and monitor these developments and ensure they comply with their securities law obligations are to have more frequent disclosure committee meetings, ensure disclosure committee members are available on short notice, and ensure that they advise management of extended periods of unavailability. Consider, as new information becomes available, whether that information, together with previous information and changes, add up to a material change in respect of your business, and regularly consult with counsel in connection with your disclosure obligations. Back over to you, Warren, to discuss forward-looking statements.
Okay. So, as we know, Canadian public companies are encouraged to provide forward-looking information and forward-looking statements if they're reasonably able to do so. However, they are cautioned that all forward-looking information, all future-oriented financial information, and financial outlooks must be based on assumptions that are reasonable. Whenever this disclosure is made, the issuer must identify the information that it is disclosed that is forward-looking, state management's assumption that have gone into developing that forward-looking information, include the cautionary language that actual results may differ, and then describe material risk factors that could cause actual results to materially differ. So in light of COVID-19, and the government response and the social response and your company's response, you know, a lot of these things represent changes that could have impacted the facts and assumptions underlying previously disclosed forward-looking information. So what we're recommending issuers do is look at their forward-looking statements. You know, is there still a reasonable basis for previously disclosed forward-looking information? Are assumptions still reasonable? Have the risks that could cause results to differ been correctly identified and disclosed? If not, it may be worthwhile to withdraw those forward-looking statements or to update them in order to mitigate the risk of secondary market liability for that forward-looking information that has ceased to be reasonable due to foreseeable but undisclosed material risks. Specifically in the context of management's discussion and analysis, the securities administrators expect a discussion of reasons why actual results for future periods may differ materially from previously disclosed material forward-looking information, and to discuss material differences between actual results achieved in the current period and previously disclosed forward-looking information and financial forecasts. So if you have had to withdraw or qualify previously disclosed forward-looking information, that should be referred to in the management discussion and analysis. And when making these disclosures, issuers are expected to discuss the events and circumstances that led to the decision to withdraw or change guidance, including a discussion of the underlying assumptions that are no longer valid and what investors should expect going forward. And that is it for our discussion of continuous disclosure. Back to you, Cindy.
Great. Thanks, Warren and Martin. It's a lot for issuers to think about, and certainly not easy topics to deal with. Not only are public companies having to grapple with the unprecedented disclosure challenges they face, many are also facing challenges meeting certain other obligations under Canadian securities laws in light of the pandemic, such as the filing of financial statements, technical reports, and MD&A. The Canadian securities administrators and stock exchanges have recognized these challenges and have provided relief for some of the standard filing requirements. I'm going to now turn things over to Martin and Michael, who will discuss what relief has been granted, what are public issuers' continued obligations, how issuers can rely on the relief available to them, and also the potential implications of reliance that issuers should be aware of. So Martin, why don't you start with a summary of the relief that is available?
Thanks, Cindy. In response to the challenges relating to COVID and the difficulties that it might present to issuers trying to file their continuous disclosure documents, the CSA has essentially issued blanket orders that provide for an additional 45-day period to file continuous disclosure documents that would otherwise have to be filed by August 31. These extensions apply to most documents required to be filed under National Instrument 51-102, including financial statements, associated MD&A, and annual information forms. Similar extensions are also provided for certain mining or oil and gas technical reports. However, it's important to remember that the relief does not extend to an issuer's obligation to make timely disclosure of material changes or to file material change reports within 10 days. To the extent there's a material change in the business, there's no extension available. The issuer has to disclose the information promptly. It's also important to note that the relief is not automatically extended, and issuers have to satisfy certain conditions in order to extend their filing deadlines. Issuers are essentially subject to three obligations. First, they must issue a press release in advance of the filing deadlines, which describes the applicable requirements for which they are relying on the extension, states that the issuer has imposed an insider trading blackout policy on its management and other insiders that is consistent with certain CSA policies, states the estimated date by which the delayed disclosure documents are expected to be filed and made available, and provide an update on any material business developments since the date of the issuer's last financial statements that were filed, or provide confirmation that there were no such developments. Second, issuers must file follow-up press releases not later than every 30 days after the date of filing was required, which provides an update on any material business developments since the last news release, or confirms the absence of those developments. Finally, issuers may not file a prospectus until it's filed all the documents for which it is relying on the exemption. I think finally, issuers should be aware that the relief was granted under two distinct sets of blanket orders. A set of orders dated March 23rd, which provided for a 45-day extension for documents to be filed on or before June 1, and a second set of blanket orders dated May 20th, which provided an exemption for documents to be filed between June 2nd and August 31. These orders are distinct, and this has a couple of implications. First, issuers have to comply with the conditions set out in the order dated May 20th if they want to extend the filing deadline for any documents to be filed between June 2nd and August 31. The issuer cannot merely rely on the press release it may have issued in connection with the first orders issued on March 23rd. A new press release must be filed. Second, the blanket orders do not extend the filing period for documents required to be filed by June 1. The extension period for those documents remains 45 days, and an issuer cannot rely on the more recent blanket orders to extend the filing deadline for those documents for 90 days. Those documents will remain subject to a 45-day extension period, as will the documents to be filed between June 2nd and August 31. And I guess over to you, Michael, to discuss some frequently asked questions and guidance that the CSA has provided with respect to the implementation of these new blanket orders.
Thank you, Martin. So the CSA published Staff Notice 51-360, frequently asked questions regarding the filing extension relief. And this notice was last updated on May 13th. The FAQs include several interesting questions, and we'll look at a few of them. But I think that the key point that we would like you to remember is that these FAQs are being added to and updated by staff of the CSA. So we encourage issuers to check back to Notice 51-360 from time to time for new Qs and As that they may find useful. So let's start by looking at how to calculate an extension period. We start counting the extension period the day following a reporting deadline. By way of example, if the deadline is August 29th, 2020, counting of the first day of the 45-day period extension starts on August 30th. And the extension period would then run until the end of, until October 13th, 2020. That's 45 days. The next question that the staff notice looked at was with respect to normal course issuer bids. So similar to the prospectus example that Martin mentioned, an issuer that is purchasing or planning on purchasing its own securities in pursuant to normal course issuer bid exemptions will not be able to do so if they're relying on the filing extension exemption. In fact, the bid must be suspended until the issuer is up to date in its disclosures. There is an exception in the case of a pre-existing automatic securities purchase plan, of course. Well, the rationale for this policy or this stance of the CSA is that there is a heightened risk that the issuer, who has not yet fully disclosed its information and possibly its management, may have material information that it can act upon. The next question that the guidance deals with is in the case of management cease trade orders, MCTOs. So an issuer subject to an MCTO will not be able to rely on the relief to extend time requirements that apply under the MCTO. And if the issuer anticipates not being able to meet those time requirements of the management cease trade order, it should in turn contact the securities regulatory authority that issued the cease trade as quickly as possible. Two other cases to which the filing extension relief does not apply are reports of exempt distribution under National Instrument 45106, as well as insider reports for transactions that insiders would make on SETI. So now we'll turn back to Martin, who will briefly discuss with you the impact of relying on the filing extension relief.
Thanks, Michael. I think it's important ultimately as a practical matter for issuers to remember that there are some significant implications and downside associated with relying on the relief, and that this might persuade them to avoid relying on the relief unless it's absolutely necessary. For example, while relying on the relief, an issuer's access to public financing by way of prospectus is essentially cut off. Normal course issuer bids likely have to be suspended. Management and insiders must be subject to a trading blackout, and issuers need to consider if their existing disclosure processes will permit them to monitor for and to disclose material business developments as they arise. On this last point, I think it's important to keep in mind that a material business development is probably not the same as a material change. A material change is assessed based on market impact on the price or value of an issuer's securities, but in its guidance, the CSA has suggested that the occurrence of a material business development should be assessed using a reasonable investment test. These two tests probably give you the same results, and there's probably a fair bit of convergence in most cases, but not necessarily. The CSA guidance seems to suggest that a material business development might need to surpass a lower threshold to be material as compared to a material change. Therefore, issuers need to bear in mind that while relying on the exemption, they could be subject to enhanced disclosure of material developments in relation to their business, which impose a greater burden than the traditional material change reporting might. Michael, back over to you.
Thanks, Martin. So Martin has raised some important considerations, and let's see to what extent reporting issuers in Canada are relying on the relief. The data is presented in 3 slides, and they should be up for participants to see. So I'm not sure if we're able to see them, but in our data, and we'd like to thank Adam Sherman for his research and skill in putting those together. Okay, great. So we see the slides are up. The first slide in our review, we looked essentially at one of the main conditions of the filing extension relief, which is the publication of a news release. And then this was mentioned by Martin earlier. So our statistics are essentially based on issuers that meet that requirement. If an issuer intended to rely on the relief but failed to publish a press release, it will not be captured in our stats. But to May 25th, 2020, we found that a total of 222 issuers published press releases of their intention to rely on the relief. And this in of itself is actually a substantial increase in the number of issuers relying on the relief. Last we were aware, around mid-April, the number of issuers relying on the relief were in the high 80s. So in recent weeks, there has been a substantial increase. In our first slide, we show the proportion of issuers relying on the relief by their listing exchange. Over half of the issuers are listed on the TSXV, 18% are listed on the Canadian Securities Exchange, and 28% are listed on the TSX. In our next slide, we examine how issuers are relying on the relief, essentially which documents they plan to file at a later date or an extended filing date. A vast majority of those issuers relying on relief apply the relief to their quarterly financial statements and or their MD&A. That's just about 86% of issuers. While only 9% of issuers intend to rely on the extension for the filing of their AIF. We believe that this makes complete sense for 2 reasons. Number one, the date of the AIF does not precede the date of the auditor's report for the annual financial information. And two, in the case of venture issuers, AIFs are not subject to a filing deadline. And our last graph that we'll put up on our slide, we looked at issuers relying on the relief by industry and find that around 42%, a large number of issuers are in the mining sector who are relying on relief. This also makes sense given the large proportion of issuers generally in Canada that are in the mining sector. And following second are issuers grouped largely in other industries. It'll be interesting to see how these statistics change over time. And we'll turn it now back to Cindy, who will take us to our last topic of today's webinar.
Great, thanks Martin and Michael. I think the key takeaways there for participants watching is that there is relief that's available, but that there are requirements you need to comply with in order to avail yourself of that relief. So ensure that, again, you're seeking proper counsel on that. So with social distancing protocols and limitations set on the size of group gatherings, this proxy season, many Canadian public companies are faced with the question of how to legally hold their shareholder meetings in a manner that minimizes health risks to the participants. Traditionally, shareholders meetings have been held in a physical location with shareholders voting either in person or by proxy, but COVID-19 is leading to public companies having to consider novel ways to hold their shareholder meetings. Our final topic today will be on the holding of virtual AGMs. And in this regard, there are corporate security laws and stock exchange policies that must be adhered to. And as we have learned through this process, there are challenges and practical considerations to this format. I'm going to turn it over to Kathleen, who will lead the discussion on this topic.
Thanks, Cindy. So we're going to break this topic down into three areas. First of all, I'm going to speak briefly about how companies were approaching this issue and some of the decisions that they've made to date, including relating to postponements. But basically, we are seeing companies move to entirely virtual meetings this year, and we'll talk about that. We're going to talk about the corporate law developments relating to holding virtual meetings in each of our jurisdictions. And then we're going to go through some logistical aspects of holding a virtual meeting. So obviously, a significant number of issuers have December 31 in May and June right now as really the busiest months of the year for AGMs. The more senior listed issuers at the earlier filing deadlines, they had already gotten the ball rolling for their meetings in early May when the pandemic hit back in early March. So on March 20th, the Canadian securities regulators issued some initial guidance on virtual meetings. It was really focused on AGMs, just the regular plain vanilla meetings with election of directors, appointment of auditors, maybe things like amendments to equity incentive plans, things like that. But their guidance for reporting issuers that we're going to be having proxy contests or getting approvals for an M&A transaction or 61-101 transactions. In those cases, the guidance was to contact the principal regulator and have a discussion with them about what needed to be done. So for those who had already put out their circulars, and that was probably a fairly limited number, the only way to really address matters was either to postpone the meeting or, which they could do, generally speaking, in the ordinary course, usually till the end of June. Or otherwise, they're going to have to communicate the limitations or the adaptations that they were going to use for the meeting, in both cases by way of press release. So what they had to do was they had to encourage people to vote by proxy and indicate that attendance in person would be limited to comply with applicable law for gatherings. Some issuers are still doing this. I think they're hopeful that they will have in-person meetings, and maybe in some jurisdictions in Canada that will be coming soon, but in others certainly not. In those early days, some people had to resort to tactics that distributed people amongst various meeting rooms so that you didn't go over the number of people who could congregate together. Those meeting rooms were then connected by phone. We even saw one case in the case of a private company client where sort of people were distributed amongst cars in a parking lot, again, connected by phone. People had to be a little bit ingenious and innovative to deal with these situations in the early days. For those that decided to postpone, in most jurisdictions, things haven't really improved enough. And at this point, there's a good chance they won't be able to have an in-person meeting before the end of June. It might be quite some time before companies can reliably host a meeting in person without at least providing telephonic or electronic access. When you do both of them together, that's called a hybrid meeting. So we can expect that issuers that have March 31 year ends to also be considering postponements and also virtual meetings. Just on the issue of postponing a meeting, obviously Canadian securities regulators, they don't establish meeting requirements. Those requirements are established under corporate law. They may be in the bylaws of the company. So you have to look to both corporate law and articles and bylaws in making these kinds of decisions. While there are variances from jurisdiction to jurisdiction, generally speaking, annual meetings have to be held within 15 months of the last meeting or within 6 months of the year end. And the corporate law relief varies from jurisdiction to jurisdiction as well. So just as an example, under Ontario corporate law, the Ontario Business Corporations Act, if you had a deadline to have your meeting, say June 30th, which was within the period of the emergency, we still have a declared emergency here in Ontario, the deadline becomes the 90th day after the emergency is terminated. Or if the deadline falls within 30 days after that emergency is terminated, then the deadline becomes the 120th day after the emergency is terminated. So there's not a clear date by which you have to hold your meeting. Right now, it's a moving target as long as this emergency goes on. But in contrast, under the CBCA, for example, the Canada Business Corporations Act, if you want to delay your meeting past the deadline, the 6-month deadline, you actually need court approval for that. So you do have to look at your corporate law requirements. You've also got the stock exchanges. They have tried to be flexible in this. Right now, both the TSX and TSXV have basically said, you can hold your meeting anytime in 2020. So effectively, they're pushing out the deadline to December 31st, 2020 for companies that had a deadline of June 30th. A postponement of 6 months is significant, and whether that's going to be acceptable to an issuer or its shareholders is really going to depend on a number of factors that you have to consider. An issuer might have a plain vanilla meeting, may not normally have many shareholders attend in person, so they may be keen to get it over and done with. Or they might want to postpone. An issuer that has special business that needs to be taken care of sooner rather than later, they may need to go to the virtual route. So we can talk about that now. When we started looking at this situation, and we looked at the corporate laws across our jurisdictions, Canada, BC, Alberta, Ontario, and Quebec, the Ontario Act had the least resistance to hosting a virtual AGM. So unless your articles or bylaws provide otherwise, you in Ontario under the OBCA, you can hold a meeting by telephonic or electronic means. And somebody who votes at that meeting has an established communication link with that meeting is deemed to be present at the meeting. Now, there might be some issuers have prohibitions in their articles or bylaws. So the way we were originally considering handling this was to amend bylaws and then go get them confirmed, those amendments confirmed by the shareholders at the virtual meeting. But we didn't need to do that. Relief was provided by the Ontario government, first by an emergency order, and then more recently by legislative amendment. So notwithstanding the provisions in articles or bylaws, issuers are temporarily, like while this emergency exists, they can hold their meetings entirely virtually in Ontario. I mean, just as a side note, it's kind of interesting. I mean, if you had called a meeting virtually on the basis of this relief, and then the temporary suspension period ended, query whether you can still hold that meeting virtually. We could actually see people having to go through the same thing, but the other way around, issuing a press release to say, we've made a change, we're actually going to have this meeting in person as well, and designating a particular location, but what we'll have to see. Martin, the CBCA and the Alberta Act are a bit more problematic. Can you address those statutes?
Yes, thanks, Kathleen. I think overall, the Canada Business Corporations Act and the Alberta Business Corporations Act are more restrictive than the Ontario Act, where virtual meetings are concerned. Under the Ontario and Federal Business Corporations Act, a company may only hold a virtual meeting entirely by electronic means if it is expressly permitted by the company's bylaws. And unfortunately, unlike in Ontario, neither the Alberta government nor the CBCA director has issued orders that would permit a corporation whose bylaws do not authorize a meeting by electronic means to hold a virtual meeting. However, there has been some guidance provided by the CBCA director suggesting that a corporation's board of directors might circumvent this issue by amending its bylaws to authorize a virtual meeting with the change effective until the next meeting of shareholders, where it can be confirmed or rejected. The Alberta government has taken a bit of a different approach and has issued an order under the Public Health Act that suspends the obligation of Alberta companies to hold in-person meetings. However, there are a few shortcomings to the Alberta order, and among other things, it does not authorize an Alberta company to hold a virtual meeting where the corporation's bylaws lack appropriate authorizing language. Consequently, Alberta companies without bylaws that authorize virtual meetings seem to have the option of postponing an in-person meeting to a later date, or perhaps amending its bylaws in the manner contemplated by the CBCA director and having those amendments confirmed subsequently at the virtual meeting.
Thanks, Martin. Cindy, I think the situation's even more complicated in BC.
Yeah, so BC's is unique, and British Columbia companies are actually required to set a physical location for their shareholder meetings. But in the BC Business Corporations Act, there's a provision that indicates, unless a company's memorandum or articles provide otherwise, a shareholder or proxy holder that's entitled to participate in a shareholders meeting may do so by telephone or other communication medium. If all shareholders or proxy holders participating in that meeting, whether by telephone or other communication or in person, are able to communicate with each other. And if one or more shareholders or proxy holders of a BC company participates in a meeting in this manner, then each shareholder or proxy holder is deemed to be present at the meeting, and the meeting is deemed to be held at the location specified in the notice of the meeting. So until very recently, what we were telling our BC clients is that they should set a physical location, whether it's at their office or their lawyer's office, have one person attend, but then in the proxy, the information circular to encourage, as well as on your website, encourage your shareholders to actually not attend the meeting, to phone in or to host a virtual meeting, provided that one person was actually in the physical location. However, on April 21st, BC also had an emergency health order issued, which provides that BC corporations with temporary relief from the location requirement for shareholder meetings, and also deems persons participating in accordance with the order to be present in person, and this assists BC companies with their quorum requirements.
Great, thanks, Cindy. Finally, Quebec. Michael, the lockdown measures in Montreal have been amongst the most stringent in Canada. So how does the corporate law deal with them there?
So Kathleen, I'm pleased to say that Quebec appears well positioned on the front of virtual meetings. The Business Corporations Act is relatively new, enacted in 2009, and the law allows people entitled to attend an AGM to participate by means of any equipment that enables all participants at a meeting to communicate directly with one another. In addition, where articles or bylaws are more restrictive, or the entity is established under a different legislation than the Business Corporations Act, the Minister of Justice on April 27th issued an order that allows participants at a meeting to participate virtually as well.
Great, thanks, Michael. So before we discuss logistical matters, I just want to highlight where we're at in the adoption of virtual meetings. While they're becoming more and more prevalent, it is still early days. Everyone's learning as they go. For most issuers, this is the first time they've done them. If we can get the slides back up, I'd just like to show you, based on our searches, as of May 24th, 2020, there were 121 issuers that had either announced or had held some sort of virtual meeting. Of those, 73% of them were on the TSX, 23% on the TSXV, and 4% on the CSE. Now, the first challenge with hosting a virtual meeting is deciding on a general platform to do so. In the past, these were quite limited. And sorry, you just see the slide now with the 73% on the TSX, 23% on the TSXV, and the 4% on the CSE. If we go to the next slide, we've had virtual meetings in the past. They were quite limited. Examples are Canada Goose. It's had its meetings entirely virtually. And the TMX group has held what we call the hybrid meetings, so both for virtual electronically, but also in person. And for those types of meetings, there was a professional provider that those companies used. And of course, that provider had a first mover advantage when this all happened, and that company's name is Lumi. So if we look at the same group of issuers in this slide, 58% of the people the companies that have had virtual meetings so far, this year, 58% of them have used Lumi, 39% have used some other methodology, and 3% are still in the process of determining. And then of the percentage who've used Lumi, that's 87% who are TSX listed issuers, and 13% which is TSXV. And why is this? Well, really, it's likely cost. The Lumi platform isn't cheap. And in these times, I think issuers are having to sort of balance the process for holding the meeting and the ease of that with cash conservation as well. So what are the alternatives? It depends on the circumstances of the company. We've seen situations where you can run a meeting by a simple telephone conference call. Obviously, it's difficult to manage if you have more attendees. Others use some kind of a webcast. If a company does quarterly investor calls and they have a webcast mechanism that they're using, this might be a reasonable choice for them. We've had other issuers who've used Zoom, and you can get quite elaborate with Zoom using its polling features. And there are a few other providers. Some have been developed for other meeting purposes, like for condos and things like that, but they're evolving their services as we speak to service these types of meetings. Aside from the cost, when you're deciding on the platform that you're going to use, you've got to consider the other logistical matters. Even if you can hold the virtual meeting, it doesn't relieve you from complying with the requirements to afford shareholders the ability to be heard at a meeting and to vote at a meeting. So some of the questions that you might ask are, how many shareholders can, normally show up for our meetings? Are we looking at changes this year in the board and the auditors? Is there special business? I mean, you've got to look at that context in making this decision. If you're looking at the various platforms, you need to think about whether they accommodate the expectations of your shareholders. Are they flexible enough to accommodate wrinkles that you might experience at the meeting? It's pretty stressful if things go wrong. If not, then you really need to be prepared to adjourn your meeting, maybe even within the meeting, or to postpone the meeting. And again, you run into these corporate law issues that we've mentioned. And you might actually have to change your record date if you have to push your meeting date out too far. So the concept of hosting the virtual meeting is perhaps a bit different than hosting one in person, and the professional systems like Lumi approach meetings a bit differently. And so you have to dig into the mechanics of their system to see what that platform does differently than what you might expect to do, and what that might mean for your particular meeting. So I'll give you an example. Lumi's standard terms and conditions provide that when a registered shareholder logs on with their control number from their former proxy and they vote in the online poll, their previously deposited proxies are automatically revoked. So this isn't the way it normally works. You can only revoke your proxy before the meeting up until the commencement of the meeting. So typically what happens is if you're a registered shareholder and you've already voted, what you really should be doing is signing on as a guest with Lumi and coming into the meeting, but then you can't really ask questions either. So, and you don't vote in the online poll in those circumstances. But you can work with Lumi to change the terms and conditions and align different processes to be more like a regular meeting. Once you have the sense of the platform, you've got to work with your transfer agent. And I think it's helpful to take a look at the typical script that you have and see whether there are going to be any issues that might arise. And I'll talk a bit more about that in a minute. The next question is how are people going to attend this virtual meeting? I mean, if you think about a regular AGM, when people come in person, they register at a desk with a transfer agent. They might be given a ballot to take in to vote on. Some, but maybe not all guests are allowed in. So these are other considerations. For Lumi and other meetings that we've done using Zoom, we've created an advanced registration process, which helps with shareholder verification, whether the person is supposed to be afforded the opportunity to be heard and vote at the meeting. It's something that might be managed by Lumi and the transfer agent. But if you're doing something and using a simpler model, then that's something that the company might have to manage. By way of example, we've seen situations where the company sets up a registration process on its website. So assuming the time permits and the logistics, can be addressed before the meeting materials are finalized, you want to get those details into the circular. You need to coordinate with the transfer agent, the whole proxy voting infrastructure. But if an issue arises subsequent to doing the mailing of your meeting materials, then your added protection is to issue a press release to clarify things. It's just that presents a bit of an additional risk in calling the meeting. Once everything's been settled and everything's in the mail, then that's when you can turn to finalize the script. You've got to think about things. Is there really going to be a real interaction with shareholders, or is it just slides coming up with a presentation? Are you going to have votes by way of a show of hands on certain types of motions? Maybe with a few attendees only, say by telephone, you could call out names and ask for votes or ask people to indicate if they're against a matter. If you've got actual motions where there are going to be ballots, normally you would have people sign up the ballots during the meeting, but maybe this is something that can be done prior to the meeting and maybe in connection with the registration process. All of this you're going to have to coordinate with the transfer agent. And so that takes me to the last point that I want to make, which is that you do have to sort this all out with the transfer agent. How are they going to report on attendance at the meeting to show quorum? How are they going to count the votes and report on them? The large transfer agents are comfortable with Lumi, even though even that is early days. But if you want to do something different, you're going to have to get them comfortable about the process. A particular concern is how to validate the shareholders who are voting in a meeting and that their votes are being counted. Your best bet is for all the votes to come through on proxies, so there isn't an issue. But if you are voting at the meeting, and obviously you have to provide that opportunity, then that's really the trickiest part, in my view, to resolve. So Cindy, that's sort of a summary of what I hope people want to know about hosting virtual AGMs. Back to you.
Okay, great. We've got about 2 minutes left, and so we've been getting some questions in. We're probably not going to be able to get to all of them, but I'll ask a few to the panelists, and then if we don't get to your question, we'll follow up with an email response. So just Kathleen, because we were talking about shareholders meetings, I thought we may as well sort of stay on that topic right now. So can you talk more about how you direct shareholders into these meetings and can be sure they're supposed to attend, and how would it work if you're using Zoom, for example?
Sure. I mean, it really is all in the registration process. Lumi had figured this out previously. Basically, registered shareholders use their control numbers on their form of proxy. And that's something the transfer agent has access to, so they can check that. Proxy holders normally have to go through dealing with the transfer agent. They have to ask for a username, and then that's what helps them log into the Lumi system. So basically, you can adapt that system for use with other means. For example, for Zoom, working with your transfer agent, making sure that you're dealing with both the control numbers and the proxy holders. You know, when you're working with Zoom, obviously you want to create some security around all of it. You know, we've seen a situation where, you know, what you do is you publish their regular website address and phone number, but people have to register in advance to actually get the link and the passcode, and that's what sort of keeps it a more secure meeting. You know, and that takes you through a registration process and a verification process, which helps you figure out whether people can be voting or not. You know, once you're actually in the Zoom meeting, you can see people just as you can now. They may not bother to show their video, but you know that they're there. And that's how you can sort of call people out to either mute, you know, to hear their questions, you know, and to call for votes. You know, and there's also the polling process that you can use on Zoom.
Great. Okay, thanks. And I'm sorry, everyone. We're already about 1 minute over, and so we are going to end today's webinar. We'll try and get back to and address, I guess, the questions that we weren't able to address offline. And also, as we said, please feel free to reach out to any of the speakers. The bios or email addresses will be obviously on our website. So thank you to everyone for attending today's webinar. We hope you found it insightful. And please stay safe and check out our next series of webinars that are coming up. Thank you.